Can I pursue a liability claim if I was partially at fault? Have you ever wondered what happens if you are involved in a car accident and share some of the blame? This is a common concern, and understanding your options can help you navigate the situation effectively. Yes, you can pursue a liability claim even if you were partially at fault for the accident. However, the amount of compensation you may receive depends on the laws of the state where the accident occurred and how fault is divided between you and the other party involved. Liability in car accidents generally revolves around negligence. This means that if a driver does not exercise reasonable care and causes harm, they may be held responsible. When more than one driver is involved, this is known as partial fault or comparative negligence. The fault is usually expressed as a percentage split between the parties. In many states, if you are found to be partially at fault, you can still recover damages. However, your compensation will be reduced based on your percentage of fault. For instance, if you are deemed 30% at fault and the other driver is 70% at fault, you could potentially recover 70% of your total damages. This system is referred to as comparative negligence. Some states follow a pure comparative negligence rule. This means you can recover damages regardless of how much fault you share, even if you are mostly to blame. Other states have a threshold, often 50% or 51%. If you are equally or more at fault than the other driver, you may not be able to recover any damages. A few states use a modified comparative negligence rule. This rule limits recovery if your fault exceeds a certain level. Therefore, it is essential to know your state's laws regarding comparative negligence to understand how your fault impacts your claim. When you file a liability claim, insurance companies will investigate to determine fault. They will review evidence such as police reports, witness statements, and photos. The insurer will assign fault percentages based on this evidence. If you are found partially at fault, your payout will be adjusted to reflect your share of responsibility. This means your damages might be reduced, but you are still allowed to make a claim. Your own insurance coverage may also play a role in this process. If you have collision coverage or uninsured motorist coverage, these can help cover your losses regardless of fault. To support your claim, it is important to document the accident thoroughly. Take photos, write notes, and collect witness contact information. This documentation can help establish your version of events and clarify the fault percentages involved. Consulting with your insurance company or a legal professional can also be beneficial. They can guide you through the claims process and help you understand your rights and options. In summary, being partially at fault does not prevent you from pursuing a liability claim. Your compensation will likely be adjusted based on your share of fault, but you still have the right to seek damages for your losses under most state laws.